Hello everyone, happy Tuesday. Brett Thompson, here's the Thompson Law Group, and here's another installment of the Teaching Tuesday, all right? The Closing Ninja Classroom. So today I wanted to talk about the doctrine of equitable title and equitable conversion versus legal title, okay? So legal title in the realm of real estate is when there's the delivery of the deed and the purchaser, for example, becomes the legal title owner of the property, okay? And then they can take their deed, they can record it in the land records, and they are now of record the title owner of the property. There is a common law doctrine of equitable title, which deals with equitable conversion. So under the doctrine of equitable title, it says that when a buyer of real estate enters into a contract, at that point of the entry of the contract, the buyer becomes the equitable owner of the property, and so they have an equitable interest in the property, and the seller then has an equitable interest in the purchase price, the cash, okay? So there's a conversion. So the seller's interest in the property converts to personal property, meaning that the seller has an equitable interest in the cash from the buyer, and the buyer's interest converts to an equitable title in the real estate. Why does that matter? The risk of loss, okay, under the common law doctrine, the risk of loss shifts to the buyer upon the entering into the contract. So, for example, if I entered into a contract today and we're going to close in 30 days, so today is the 18th of January, so we're going to close on February 18th. Let's say on February 17th, the day before closing, the house that I have under contract gets hit by lightning and burns down to the ground, okay? Total loss. Well, under the doctrine of equitable title, I still have to pay the purchase price to the seller, and I have to close on the property because I have obtained an equitable title or an equitable interest in the property. Now, the powers that be in RAIN, the Real Estate Information Network, so if you're a real estate agent and you're using these RAIN contracts here in Hampton Roads in Virginia, the contract can overcome the doctrine of equitable title and equitable conversion. So the current RAIN contract that this version came out in January of 2022, paragraph 12 says at the bottom, the seller assumes until settlement all risks of loss or damage to the property by fire, windstorm, casualty, or other hazards. That one sentence is very, very important, and it was put in there for a reason, and it was put in there because of the common law doctrine of equitable title. So this overcomes the common law doctrine and shifts the burden or the risk of loss back onto the seller. So if you're using the RAIN contract and the house gets burned down or something happens to the house prior to closing, the buyer does not take on that burden, all right? So the buyer would not have to necessarily purchase the property. So the risk of loss would remain on the seller. So there's legal title and there's equitable title and there's equitable conversion. So that was just kind of like a little snapshot example of the doctrine of legal title. So if you're not using a RAIN contract and you enter into a contract to purchase real estate, make sure that your contract has a provision in there that clearly states that the risk of loss remains on the seller until the date of settlement. Hope that's helpful. Thanks, guys.